Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is an attorney from San Jose, Raymond Sheffield. And Ray has his own law firm and he specializes in trusts and estates. The law office is in San Jose, California. Been a lawyer for 10 years. Ray received a JD degree from Santa Clara University, and then he received an LLM degree in estate planning from the University of Miami in Florida. He tells me that he loves the role of counseling clients for their estate planning. And in addition to his law practice, Ray is an adjunct professor in the Golden Gate University LLM in tax program. Ray and his wife live with their two adopted daughters, ages 2.5 and 4, who are from Russia, in Almaden Valley in San Jose, California. So welcome, Ray. Thanks for joining me today.
Thanks for having me, Mike.
Okay, folks, today we're going to be talking about estate planning for retirement accounts. This is actually a very specialized area, and so I want to give you a caution that we're discussing a very complex area again. This is intended to be a starting point for a bigger discussion. You should get qualified legal and tax advice, and also Ray and I both work in California, so we're thinking about things like California community property and so forth. The issues vary a little bit from state to state, and so viewers in other states particularly should seek advice about their local laws, but in any case, this is just a starting point. So with that, I'm going to get started with some of our questions. So Ray, why are retirement accounts a special class of assets for estate planning?
Well, Mike, Congress didn't intend an IRA or a 401k to last forever. They intended people to use that money during retirement. Of course, sometimes people don't live out to retirement, or there's so much money in the account that you can't spend it all. And so that's why Congress created these special rules to deal with this type of asset.
Mm-hmm. Okay. I think another thing related to this that we talked a little bit about before is that this is one of the types of assets. Another one is life insurance in many cases, but a lot of times the documents themselves, like an estate or a will or a trust, they don't address the retirement accounts because you have named beneficiaries and so forth. Or you may even actually have like trust language in the beneficiary language of the account.
That's true, because you normally create a beneficiary designation when you open up this account, or maybe modify it later. That supersedes whatever is in your will or your trust. And so it's very important that you coordinate what is put on that beneficiary designation with your overall estate plan, or you can have money going to places you otherwise wouldn't want it.
Right. Okay, well here is kind of a big one, because it's something really that people have to deal with every day when they have these plans established, and maybe they don't think about it as much as they should, and that is, what are some considerations in choosing a beneficiary for a retirement account?
Well, generally the first thing we would want to look at is give to charity rather than to individuals. If you're going to make any charitable gifts when you die, the IRA or the 401k is the best place to make those, because those charities don't pay any income tax, where the individual, your children or something, will have to pay income tax. Then secondly, we look at younger people rather than older people, because they'll get the benefit of that stretch out or deferring the ability to keep the money in the plan for as long as possible. Older people just, they're not going to live as long, so they have to take the money out faster. And then thirdly, we look at, lower income tax bracket beneficiaries versus higher income tax bracket beneficiaries. So we may not always want to give things equally. If one child is a school teacher and the other child's a cardiologist, the school teacher probably is a better beneficiary because they're in a lower income tax bracket. They get to keep more of the money.
Right. So there's this income tax wrinkle, tax rates and so forth, or even whether you can escape tax. And part of this has to do, of course, is whether you have other assets to compensate. So for particularly for the wealthier clients, okay, well then they can choose to give certain assets. Like I said, maybe you'll have got an irrevocable life insurance trust to take care of your children and wife, and then maybe you have a charitable intention that you can take care of with the retirement account or something like that.
Exactly.
Yeah. Okay. So you mentioned stretch out when we were talking about this. What does a stretch out mean?
Well, most people know that when you turn 70 and a half, as the participant in one of these, you have to start distributions, minimum required distributions. Mm-hmm. Well, when you leave money to your children, and there's a special exception for the spouse, I'm sure we'll talk about in a minute, but when you leave money to your children or grandchildren or some other person, they're required to start minimum distributions right away. Mm-hmm. And those minimum distributions can theoretically last over their life expectancy. Mm-hmm. So we call that stretch out, stretching out the distributions over life expectancy. Mm-hmm. The problem is that if you've named the child outright, they can just take the money all at once. Mm-hmm. So in some sense, while we plan for stretch out, it may be a little more of a myth than the reality, unless the client actually forces the child to stretch out over their life expectancy.
Right. So maybe we should talk about, again, just to sort of elaborate a little bit, and that is that when a beneficiary, other than the spouse, receives the account, so then you determine a life expectancy at that point. And there's no recalculation, and so that just determines the schedule. Each year you drop a year off, you divide the beginning balance of the account by that, and then determine how much has to be distributed for the year. For a spouse, though, you get to recalculate each year, as I recall.
If the spouse has done a rollover.
Yeah, yeah.
If you could require the spouse to do things so they can't roll over, and then they would be under the normal rules like anyone else for stretching out.
Yeah, so we'll go over that. Well, actually, that's in a sense our next question anyway, so let's maybe get into that. So let's talk about estate planning considerations for retirement accounts relating to the surviving spouse. What are some of those concerns?
Well, first, if you have a 401k, for example, it's governed by this law called ERISA, and essentially requires your spouse to be the beneficiary of that 401k plan. So unless the spouse signs off saying that it's okay to name somebody else, they're automatically, just because they're married, your primary beneficiary on the plan. Mm-hmm. If you leave the money to a spouse, right, normally what the Fidelity, Janus, Franklin, the various mutual fund companies or brokers are going to tell you is you do a rollover into your name, so the spouse now becomes the participant of the plan, just like you were the participant while you were alive. Yeah. But maybe that's not the best thing for your spouse. For example, right. What if this is a second or more marriage, right? Mm-hmm. You may not want the spouse to be able to roll the money over, because then it becomes all theirs. They can take it and then leave it to their kids or their future spouse. Mm-hmm. So in that case, you want to leave the money in trust for the spouse, where they have limited access, to that money, so that they're able to, they can get income, they can stretch it out over their life expectancy, for example, but they don't control who ultimately gets it when they die.
Right. I think there's another thing that